disability insurance policy or plan that a lawyer needs to be looking for when they're shopping for a new policy. As I've said, there is no uniform disability insurance policy or plan in the United States. Now, we purchase disability insurance as a safety net to provide us with financial peace of mind if we become disabled. Your entitlement to benefits, the amount of benefits, how long you get the benefits, what law governs the benefits, those can all make a difference in whether you have financial peace of mind. So before you go out shopping for new plan or policy or review your policy or plan, I think there are 7 important terms that you have to consider because it will make or break your finances. Number 1, what law governs? If you've purchased a disability insurance policy on your own or through an insurance agent, you most likely have a private disability insurance policy governed by state law. On the other hand, if you purchase that disability policy through your employer or an association, your policy is going to be governed by the ERISA Act. Now, there are exceptions. If you work for a church-based employer or a state governmental agency like Pinellas County or the city of St. Petersburg or the state of Florida, your policy or plan is going to be governed by state law. And so where you end up in litigation, be it state court or federal court, is key. You want to be in state court. 2, if the policy or plan is governed by ERISA, is there a get-out-of-jail-free card provision that makes it hard to overcome a wrongful claim denial or termination? Now, many disability policies have what I call a get-out-of-jail-free card. It's a discretionary clause. We didn't learn about this in law school, and discretionary clauses are also known as arbitrary and capricious. Now, what we may think as lay people is arbitrary and capricious is not arbitrary and capricious in the world of ERISA. The courts will use the term unreasonable, but unreasonable is really not the right term in my view. The term that we should be thinking about is, do you have what's called a de novo standard of review? In other words, do we have a situation where the disability carrier has not reserved discretion in themselves, and as a result, a judge can substitute their own judgment for that of the disability carrier? Otherwise, it's going to be tough to overcome a wrongful claim denial or termination. Now, each federal circuit has their own standard of review. Here in the 11th Circuit, we have a multi-step test, but it boils down really to 3 primary things. 1, we have to establish to the judge's satisfaction that the decision is wrong. And if the judge says that the decision is right, you lose. But if the judge says the decision is wrong, you don't win because you have to go to the 2nd step. And that is to show that the decision is unreasonable. Now, case law is pretty clear. The disability carrier gets to pick and choose who they want to believe. They can use their liar for hire doctors and pick their liar for hire doctors over your treating physician's opinions. So if the judge says, look, I don't like this decision, but I see this reasonable basis. I mean, they got a liar for hire doctor who says you're not disabled. It's very hard for the judge to overturn the denial. If the judge says, look, I don't like this decision and I don't think this decision is reasonable, you still don't win because it's step 3, and I've boiled this down from 7 to 3. You have to show that the decision of the carrier has been, or the plan has been influenced by their bias. And that bias is the result of a conflict between their role as the decider and the payer. Now, in the 11th Circuit, we have an awful decision that basically says we have limited right to take discovery. It's the Howard versus Liberty Life case. And that makes it very difficult to show that there is this bias as a result of conflict. And we have to prove all 3 things. So it's just not a question of, am I disabled? It's a question of whether you can overcome a wrongful claim denial or termination based on the applicable standard of review. Number 3, what's the definition of disability? Normally, the definition of disability is the inability to perform your own or any occupation. And normally, own occupation definition is paid for 2 years. Then after 2 years, it changes to an inability to perform any occupation by virtue of your education, your skills and restrictions, and your limitations. And the real world situation might be that you really can't do another occupation. But if the disability carrier can show that you can do a sedentary job sitting on your rear end all day, then they're probably going to terminate your benefits. 4, what's the definition of occupation? Now, occupation can be defined as the occupation you were performing for your employer at the time you became disabled. Your occupation is performed by the local economy. Your occupation is performed in the national economy. Your occupation is described in the Dictionary of Occupational Titles, or your occupation is based on your board certifications. And the starting point to proving your disability is to understand the policy definition of occupation, because you've got to work backwards from there. 5, policy or plan limitations. Now, benefits can be limited to just 2 years for conditions like mental nervous conditions or self-reported or subjective medical conditions, and even substance abuse. So you need to understand, are your benefits going to be limited? And if so, how are they going to be limited? Number 6, policy or plan exclusions. It's not unusual for policies or plans to exclude coverage for self-inflicted injuries or injuries related to crime or war. You also may have a policy or plan that limits your coverage for a pre-existing condition based on a rider. So let's say you've had prior back problems. You get your disability policy and they say, we'll insure you, but we're going to issue a rider that excludes any disability caused by your pre-existing herniated disc. And you have a slip and fall and you become disabled as a result of an aggravation of that pre-existing herniated disc. The plan or policy is probably going to deny your benefits. 7, what are the filing and appeal deadlines? Deadlines matter. And commonly in an ERISA disability case, you will only have 180 days in which to file an appeal of a denied or terminated case. And the appeal is the trial of your case. If you fail to timely file an appeal, you can be barred from filing that lawsuit in federal court on the basis that you haven't exhausted your administrative remedies. And by the way, there's also time limits in which to file a lawsuit. These time limits can be found in the policy or the plan, and they're also subject to applicable state law. So making a mistake with any of these types of policy plans or provisions can result in financial disaster, regardless of how disabled you are. Interpreting the terms of a disability policy or plan can be difficult, even for lawyers. I think you should have a policy review of your current policy to understand what you've got. And if you're looking at policies, you shouldn't be relying on the agent to tell you what it is you're getting and how the policies or plans may work together or not work together. If your doctor has suggested to you that you're unable to work because of a disability, I think you should be consulting with an experienced disability attorney before you stop work and apply for your benefits. Because I assure you, representing attorneys across the United States, there are lots of things we need to do to get your claim ready to file before you stop work and apply for benefits. You have to understand what your plan or policy provides. You have to understand how to pick the right day to become disabled. You have to understand what medical proof will create a winning disability insurance claim. I don't care if you're a personal injury lawyer, a Social Security lawyer, a contracts lawyer, you name it. I don't do that type of work. I do one thing. I do ERISA disability and ID disability litigation. That's the kind of expert you want to be consulting with. As Abe Lincoln said, a person who represents themselves has a fool for a client. So don't be a fool.